Why are you not arguing for the retention of sidewalk? You're having trouble making these distinctions, and a lot of judges have asked you questions about how to do that. Why are you not arguing for the retention of sidewalk? Are you assuming that the court's already decided that?
No, I'm not, Your Honor. What I'm assuming is that there is a real need to take account of Rule 52. I'm in the same position, and our brief was filed before, but the same position that the United States government's announced. I actually think sidewalk works pretty well. It's simple. It does give you uniformity. It does allow you to vary the deference given to district court's findings based on the weight that can be given that we discussed in our brief at some of these lengths and that Judge Michel talked about. I like how it works. It just runs up against Rule 52A. And as a trial lawyer, my instinct is let's see how difficult it would be if we carved out a narrow exception that actually conforms.
Let's experiment and see how difficult it would be to change it.
My view would be that because if this court carefully limited and didn't allow people to come in and say everything's a fact, first you need to show that there is a specialized meaning to a term before you get an expert who can testify what the meaning is. That didn't happen in this case. There is nothing from their expert, Robert, that voltage source has any meaning at the time.
I just don't even understand how we could possibly, even if we wanted to, do what you're asking us to do. In light of the Supreme Court's language in Markman, the penultimate sentence in the opinion is treating interpretive issues as purely legal will promote, though it will not guarantee, intra-jurisdictional certainty through the application of stare decisis on those issues. That is the second to last sentence. And the very next one is, accordingly, we hold this interpretive issue is for the judge. This issue, this legal issue, you want us to conclude that the ultimate issue is one of fact. I don't see how we aren't expressly prohibited by the Supreme Court's Markman decision from doing that.
The court was clearly referring to the difference between who the fact finder, the question of who the fact finder should be, judge or jury. There was never any effort to determine the relationship between the district courts and this court.
They referred to the interpretive issue. Treating the interpretive issue as purely legal will promote intra-jurisdictional certainty. They're talking about us.
They're also saying...
there is no other intra-jurisdictional certainty, right? We're the only intra-jurisdictional place.
Well, it's just what the government said in its brief. That's the questions that were issued in this case just were not before the Supreme Court. And I think the problem with Markman is that if you take language in isolation, as everybody does, as this court did in 1998 with Cyber itself, and viewed that as a complete affirmation of everything in the rationale of the decision. If you isolate certain parts of the decision, you can get where you want to go. But the fact is the Supreme Court was not considering the issue of deference and the tricky question of mixed fact and law about whether that should be reviewed.
In your brief, you echo something that the PTO also suggests, which is that questions of historical fact can arise and that those should be given deference when decided. I don't understand what that means. So will you explain to me what you think a historical fact is?
A historical fact is a fact that needs to be decided outside the patent. The patent can't answer the question, a textual analysis, and so you need to go to some extrinsic evidence in order to understand an important fact that is then needed in order to...
Is the ultimate question of what one of skill in the art thought the term meant at the time the patent issued a question of historical fact?
No, it's not, Your Honor. It may be that what words used in a patent meant outside the context of the patent could become relevant in some context.
Why isn't it always relevant? Absent a patentee acting as his own lexicographer, why doesn't the question devolve in every case into what did people of skill in the art think the word meant at the time? That's the quintessential definition of plain meaning, as I take it.
Well, I think one thing you'd want to know is what people of skill in the art thought of particular words. Most of the time, that's not in dispute. Most of the time, that's not.
Really? Because, let's see, 7 years on the bench, that seems to be all you all dispute about.
Let's take this case for example. There is no dispute as to what voltage source means. between the experts. That's why we didn't put in a countervailing expert declaration. They put in a declaration that said voltage source means an AC source with a rectifier, or a DC source like a battery, a solar cell. Yeah. So you're right that at some level you need to know what voltage means, although most federal judges wouldn't need much help with that. There isn't really a dispute, so there's nothing to decide. There's no need to go to extrinsic evidence. You may have a tutorial or some assistance from an expert so that the judge, in doing the textual analysis that claim construction requires for patents, has a better understanding of the patent. But in most cases, we don't think there is a need to go out and consistent with what the U.S. government and others have said, we don't think there's a need to go outside the patent itself.
Can I ask you something? I thought I heard you say in your explanation of your expert's testimony about why this term was limited to the AC power source and therefore to rectifier, you kept saying, in the context of this patent. Suppose we were to think that any change in CYBOR was limited to the meaning of the term outside the patent, historical finding in term of art in industry, but in any event, not your broad position that you take account of the whole thing, the whole intrinsic evidence, but just a question about meaning before you start looking at what the context provides. If I understand what you said, your expert did not say, putting aside the context of the patent, this term outside the patent would be limited to a rectifier.
The way I read the expert declaration is looking at particularly how we have AC power lines
in the patent.
Right, which is, of course, in the written description. Okay,
so your position and your characterization of his testimony really does depend on treating as a factual matter an analysis of the term in the context of the patent.
I think that MIT and Lighting will certainly stand for the proposition, and of course, in Venio, I don't see how you could possibly look at plain language in isolation to see if somebody would connote this would connote structure to somebody. You have to have some understanding of the intrinsic record to know whether that's true or not. You can't just look at plain language.
So
historical fact question. I don't understand the characterization. I'm really confused about this language, and I'm trying to understand it, but it seems to me what the meaning in the art was to one of skill in the art at the time is the ultimate inquiry in almost every patent case, save for the patentee acting as his own lexicographer. So if that is a question of fact, I feel like I must be misunderstanding the PTO's views, because you two are representing a small sliver of a change, but yet if I adopt what I'm understanding as your historical fact argument, to me it's the whole ball of wax. And so I think I'm misunderstanding you, and I want you to explain it to me so you make it clear why it's a small change and it's not the all-the-time inquiry.
Your Honor, I would start with the observation that lexicography is not the only legal canon of construction that comes in at the end. There's lexicography, there's claim differentiation, there's disavowal, there's what happened during the prosecution. So even if a claim term had a meaning in the art at the time, that's not the ultimate question. The ultimate question is, what does the claim mean in this specification with this prosecution history? Now, what the historic fact would be, for example, suppose a claim used a term like high-pressure valve, and the patent was directed to a certain plumbing situation. And evidence comes in, they say, you know what, I was a plumber in the time. I had a truck, and I had a drawer that said high-pressure valves on. We all did. And this is what a high-pressure valve was. And let me show you my manuals about how we did our operation. And it said high-pressure valve, and everybody knows this is what a high-pressure valve is. The district court can say, okay, that's enough. I accept that when this application was filed, the term high-pressure valve existed in this art, and as a fact, this is what skilled artisans understand.